Hello, I'm attorney Joseph Niven. I'm here to talk to you about the process for getting a family court order of protection. The first question is, why might you need a family court order of protection? The point of an order of protection is to protect you from domestic violence. It doesn't even need to be physical. It could even be stalking or even incessant messages over social media or SMS. The first step is to file a petition. In the petition, you need to allege two things. First of all, that the family court has what's called subject matter jurisdiction. What that means is that you have the type of relationship with the other side that would allow the family court to issue orders in your case. Examples are if you're related by blood, like brother, sister, cousin, child, parent, grandparent, grandchild, or related by marriage. So, for example, if you are the spouse of the other side, if you're the other side's ex spouse, or if the other side is one of your in laws. Additionally, another relationship could be that you have or had an intimate relationship with the other side. It's usually a dating relationship, but it does not even need to be a sexual relationship. The next thing that you need to put in your petition is that the other side did something that was against the law that qualifies what's called a family offense. So once you file your petition, you will see a judge or a referee either that day or the next day. And you will ask for what's called a temporary order of protection, meaning that while you're going to court, that the other side has to abide by certain conditions. For example, the conditions could be they have to stay away from you, that they can only contact you regarding your children, or that they simply cannot commit any family or criminal offenses against you, that all of their behavior towards you has to be lawful. The next step is to get the other side served. Often the court will order the sheriff to serve the other side, so this way you don't need to worry about it. You will get a court date where you will have to prove that the other side was served. If the court ordered the sheriff to do service, then the court will already have that. At that appearance, which is called return of process, the court will find out whether or not there's been a settlement of your case, meaning perhaps that you no longer want to go forward with it, or that the other side is agreeing to give you an order of protection. If there is no settlement, then there will be another court date for what's called a conference, where the court will try to help you to settle it. Like, for example, um, in most cases, the most that you'll be able to get is a 2 year order of protection. Perhaps you can agree to a 1 year order of protection or a 6 month order of protection. If you can't settle it, then it will be put over for a trial where you will have to prove your case with evidence and witnesses. All of your witnesses will be cross examined by the other side, meaning ask questions. The other side will ask questions to try to show either that the events didn't happen that you say happened, or that there's more to it than that. The court the court will also determine which of your evidence they want to accept. Like, for example, you can present police reports or photographs. After you present your case, the other side will get to present their case. They will present witnesses that you will get to cross examine, and they will also present evidence that you will have the opportunity to challenge. At the end of the presentation of witnesses and evidence, the court will have to decide, first of all, whether or not there is subject matter jurisdiction, meaning whether or not the two of you have enough of a relationship for the court to issue orders, and also whether or not family offenses occurred. If the court finds that you proved your case, then they could issue an order of protection for up to 2 years, or in some of the more severe cases, up to 5 years. If the court finds that you failed to prove your case, then your case will be dismissed and there will be no order of protection. Now, orders of protection can take some forms. Like earlier, I referenced what could go into a temporary order of protection. The same questions come up when deciding final orders of protection. The court can order the other side to stay away from you completely, stay away from you except when necessary to do, let's say, exchanges of visitation if you have a child in common. The court can order that you only communicate with each other about your child in common, or that you cannot communicate with each other at all. The court can simply order that the other side act in a lawful manner towards you. If you have further questions about orders of protection, please call us at 347 642 0376. You can also reach out to us through our website at www.nivenlaw.com. I look forward to speaking with you. The first 30 minutes are always free.